and I'm going to go to the substantive thing I really want to discuss today. Now, environmental justice started from the United States in 1994, and simply means fair treatment and meaningful involvement of all people regardless of race, color, national origin, and income with respect to development, implementation, and enforcement of environmental laws, regulations, and policies. And this from the United States Environmental Protection Agency. Now, from that moment, environmental justice has gone far and wide. It's moved from race to ethnic origin to what you get out of your natural resources and all that. So it's really been wide, which I don't want to go really into now. But the key thing is that from the definition of environmental justice, we're looking at treating people fairly and people being involved in what concerns them. In this paper, I'm actually looking more at the procedural environmental justice, which is access to environmental information, participation, and access to justice. Now, again, I'm dwelling on access to justice because I'm looking at access to courts. Now, this is actually broad meaning of access to justice, which we don't really need to involve ourselves with. But in environmental matters, access to justice refers to judicial and administrative remedies and procedures available to persons aggrieved or likely to be aggrieved by an environmental issue to have the case, whatever the grievance is, to be heard fairly, reasonably, speedily, impartially, and justly. I try to mention the key principles. It has to be just, it has to be fair, the procedure has to be appropriate, it has to be speedy, understandable, responsive, certain, effective, and adequately resourced. The basis for access to justice in environmental law, it all started, I'm sure the first speaker mentioned it, from 1992 Rio Generative Declaration, that environmental issues are best handled with participation of all concerned citizens at the relevant levels, effective at the relevant level, effective access to judicial and administrative proceedings, including redress and remedy, shall be provided. Again, after that, a lot of treaties and even national instruments have this, North African Agreement, American Agreement, it's Article 6, Article 7, then OUS Convention, Warsaw Obligation, and really many of them. Now, I'm going to dwell a bit on this, the limitations of access to justice. We all say access to justice, but generally, in the developing world, in the developed world, we have this issue of how to access justice. We all agree that it's okay for the aggrieved person to access justice, but we know that they'll have these limitation problems that stop people from accessing justice the way it should be. The first one is cost, and she mentioned it in her own presentation. There's always issue of cost. It's even worse in developing countries because, we can see that we're not very rich. And if even the NGOs, even at this time, because they actually been the source of helping people from developing countries to really access justice. But the cost issue is actually a big issue. A lot of aggrieved people are very poor. They cannot access the court fairly. They may not be able to access, get good lawyers. And issue of standing, I think it's actually been, we've discussed it a lot today by the first two or three speakers. So local standing is a major issue. Now there's actually a delay issue, which is again what I'm going to dwell on when I want to talk about Nigeria per se. But again, I just try to put the lockdown quote in here that delay of justice is a denial of justice. Now, sometimes you find out that you go to court, you spend like 10, 20 years trying to get an issue resolved. By the time you even get so-called justice, in my view, it might not really be justice because you've wasted so much time, so much energy, so much effort before getting this matter ruled in your favor. Provisions of the laws, some of the laws are actually restrictive. You have problems with that you don't actually like. It's not allowing you or a aggrieved person to actually have access to courts fairly. Sometimes have the geography issue that courts are actually situated in far places that a group person might not access to be able to get to court where they are. Then judicial review issue, judicial review is about remedies, procedures. It's not really about assessing justice per se. Again, I have problems with the knowledge, and lots of people are not aware. Just like one she mentioned in her presentation as well, some people don't even know where the courts are, they don't even know the right court to assess and all that. So again, that's the problem. We have non-experts. Until recently, the issue of environment and discussion is not really, it's not actually at the forefront. And for developing countries, it's worse because people don't even know what the environmental court or environmental lawyer, or so it's again an issue. Now, these are actually what they call, some jurists, many jurists, and judges say about access to courts and access to justice. It's just for our own knowledge. Now, generally, the courts help litigants or accused person in actually assessing justice by three main ways: interpretation of the laws, common law, and in judicial review. So by the court interpreting the laws, already made laws, they actually help in the litigants or the accused person in actually assessing justice. Now, depending on what the way the judge sees or the court sees, the interpretation of the law is actually an issue, because if when the court uses its inherent powers in interpreting these laws, if there's a narrow interpretation, for instance, it may actually affect access to justice for the accused person. Again, in common law, like tort principles, negligence, nuisance, and all that, again, it depends on how the court interprets that. And this is actually when the court comes in. In Nigeria, to be precise, I don't want to go into the issue of the laws and what it is, but obviously some of the laws are very restrictive, they are very narrow, they are not actually even reviewed. So the court should interpret some of the laws stricto sensu, that means many of the accused persons will be denied access to justice. Now, again, the common law issues, like I've already explained, it just depends on the court. So the court's its role in actually making this the court accessible to the litigants is actually very, very important. Judicial review is another issue. Like I've mentioned it before, we have a lot of issues with that. It's not actually really helping accused persons to court per se, because it has like limitations. It only talks about illegality, irrationality, procedural errors, and all that, as actually enunciated by the law in the case that is there. And if you look at the outcome of judicial review, again, in my view, it might actually help in making certain decisions, but it may not actually really help accused persons to really get justice, as it were. It has problems of funding, costs, and standing. Again, the same standing recurring in many places. Now, this is actually where I want to dwell on, because this is on Nigeria. Now, I've actually mentioned all these problems, and what I want to do now is I want to look at a few case studies to see how the Nigerian courts have actually tried to interpret some of these cases to actually help the litigants or accused persons to actually access justice. Now, we have few decisions, just few case studies that I picked on standing, that again has been recurring all the time. There are a few cases here, SDBC versus Otoko. There's actually Court of Appeal decision, which is the second highest court of the land. In that case, standing was actually denied because the litigant, the court views the litigant, no, you shouldn't represent the community in this case, because you don't have anything that you suffered above others. So in that case, it was denied. And in actually another case where the Supreme Court looked at it, like Supreme Court is the highest court of the land in Nigeria. Again, in that case, because originally standing has always been restrictive, just like in many other jurisdictions, really, but for some time, many jurisdictions, they are becoming liberal, allowing NGOs, allowing people in representative capacities to actually access courts, represent the poor people or the ignorant people that cannot really access court fairly. Now, in the Supreme Court, in one case, they all know you can actually represent your community, and that's actually in another versus interland There are many other cases there. Bembe versus Shell, this is actually a major case that we always actually look at. But there's still confusion. I specifically decided to put Court of Appeal or Supreme Court in some of the cases to show how, inconsistent some of these decisions are. And I specifically put the years as well. You can find out that in some of the cases, even after being liberal with the standing, you still find out that, in one occasion it's still restrictive as far as decisions in standing is concerned. And when you look at the decisions again, in compensation, even though the court actually, maybe there's no restriction, you have the standing, you're able to access the court, but you're not able to really get what you think as an aggrieved person, as what you think that is justiciable, or what you think that you've actually gotten justice. The compensation issue is not really what I want to really deal with there, but there are a lot of cases where somebody is aggrieved about a particular thing, like the cases I've listed here, and you move your case from high court, which is the lower court, up to Supreme Court, and you come up with damages of $100 or $1,000. In my view, again, it's not like justice, because it's just like you wasted all your time, all your energy, all your resources. Recently there is actually an improvement in remedies or compensation aggrieved persons from Nigeria in particular debt, but whether it's enough is something that will be looked into. There are decisions on strict liability, negligence. Again, in many cases there's this inconsistency. Like in one case, the Supreme Court, the highest court of the land, the decision will be like, there's negligence, you can actually get money or you can get damages. But in another case, after one case, you find out that the same Supreme Court will say, no, there's no negligence. Even if there's negligence, you're not entitled to compensation. So there are really very many issues here, decision on injunctions, nuisance, trespass, and so many other of them. Now, I'm particularly interested in this case, the issue of expert witnesses. Now, you find out that, especially in petroleum industry, you find out that it's actually a technical industry, and most times the poor illiterate people in the villages will not actually know anything about expert witnesses. Even when they do, they cannot afford it. Now, when they take multinational oil companies to court, you find out that they can't afford. Many times there are a lot of cases, sorts of cases, which are not actually, I didn't put them here, but most of cases, you find out that they will lose the case because they cannot prove certain things. I actually am an advocate of the fact that because of the technicals in the industry, the court should actually shift the burden of proof to the oil companies or energy companies, because if they do not do it in very many occasions, except for with the help of the NGOs, then people cannot get justice. So analyzing these cases, I've said most of these things anyway, but analyzing these cases, I can say there are a few, there are improvements on the issue of standing, because recently from 1990, you have some cases that standing are allowed, and there's this issue of compensation improved, but there's still problem, in Nigerian courts now, how they actually help people to access justice. You still have a lot of adjournments. One case was in court for 40 years. I have another one 14 years, Daniel versus SPDC, and in all these things, all these aggrieved people, they are in court, they are incurring costs, and of course they are poor and all that. So these are actually issues as well. So there's still really, there are still major problems. And in conclusion per se, I can say that based on my finding, there's still problem of access to substantive and procedural justice. There's still inadequate remedies, improvement in recent decisions, but still not strong and systematic. And there are still issues that the court needs to address in helping victims access justice. And that's what we can see. Recently, we have this trend of people, or aggrieved people, going outside the shores of Nigeria, going to UK, going to Netherlands, and even one in the United States, and many in the United States, still trying to get justice, because most of the time they feel that no, the procedure or the court in Nigeria is not helping them enough.